what should you do if your ex is trying to modify the custody agreement? Well, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm is a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. Well, the question of what to do if your ex is trying to modify the agreement really presupposes a couple of different scenarios. It could be that a motion was filed to modify the custody, and that's the step that the ex took to try and modify it. Well, if you receive such motion, you got to bring it to your lawyer immediately. It's time sensitive. You got to bring it to them immediately. An answer's got to be filed. A notice of hearing has to be set up. The court will have to take testimony on whether or not there's a significant change in circumstances to support even looking at the custody again. And B, if the court finds that there is a change, should we make the change? In other words, yes, there's a change in circumstances, but does that mean we should change the custody? Just because the circumstances have changed does not mean the court's going to find that we got to switch the custody also. But that is a prerequisite for the court even revisiting the issue of custody. Now, step two, if by asking this, my ex is trying to change custody, what should I do? If you mean by that you have a custody agreement that says, you have 5 days and they have 2 days, and then the next week you have 2 and they have 5, or however the agreement is. If, let's say, you have a joint agreement and all of a sudden they're taking all the time, or all of a sudden the other way around, you're supposed to be sharing the responsibility and your ex is foisting all the responsibility on you, and in that sense, trying to change the agreement, you need to take steps about that. I don't mean that you shouldn't be okay with an occasional accommodation. I think parents should occasionally accommodate one another and work within the agreement. But if you see that all the responsibility is being foisted upon you, for example, and it's supposed to be joint, the child support is based on joint, but in fact, your ex is trying to change that agreement and giving you all the time, never taking any time with the kid, all the while benefiting from the joint child support arrangement, you should be filing a motion. You got to let your lawyer know that this is going on, and your lawyer will file a motion to change the custody to reflect what is actually being practiced, to reflect the reality. That's what should go on. The court doesn't know that its orders, as they're written and as they're signed, aren't being followed unless you bring it to the court's attention. And it won't be adequate to say to the court, well, for the last year, blah, 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 blah. For the last year, the court's going to say, look, you filed this October 28th. Now it's, November 14th. I don't know about the last year. I know that for the last 2 weeks while the motion is pending, I see what's going on. And I made changes. But I'm not going to do so. You want to sit with a problem for a year and sit on your rights and not do anything about that is on you. But as far as the court's concerned, it does want its orders to reflect reality. And therefore, if there's something going on that really reflects a change, you should be getting with your lawyer so that your lawyer could consider filing a motion to adjust the order to reflect the new circumstances. If you have any questions about that, reach out. We'll be glad to help you out.